Executive Director of the Mid-Atlantic Innocence Project, which works to prevent and correct the conviction of innocent people in D.C., Maryland, and the District of Columbia. And we are really excited to be co-sponsoring this event today with Georgetown's Office of Public Interest and Community Service and with the Innocence Project, a national organization based in New York that works to seek post-conviction DNA testing in cases where such testing could prove innocence. We're here today just days before the U.S. Supreme Court hears oral arguments in the Osborne case, which is looking at the issue of whether there's a constitutional right to post-conviction DNA testing that can prove innocence. And we're really thrilled today that we have a lot of wonderful guests from around the region and from all over the country to talk to you today about why this is such an important case and about the kind of impact it's going to have on a lot of the people who you may not see today, but who the people here today represent. We have people with personal experiences who have been wrongfully convicted. We have a police officer here who has experience with wrongful conviction cases. And we have a victim here who misidentified her rapist and is now working to get him exonerated. The first person I want to introduce today is Professor David Rudovsky. He's going to give an overview of the Osborne case so that you understand kind of what the legal structure of the case is. And he's a senior fellow at the University of Pennsylvania School of Law. And he's one of the nation's foremost authorities on criminal law, constitutional criminal procedures, and evidence. And in particular, of relevance today, he's one of the nation's leading minds on federal post-conviction remedies, and they're the very issues that are actually raised in the Osborne case. So thank you, Professor Rudovsky.
Thanks. Nice to be here, and nice to see some friends I've seen before. And there is a very important case coming up in the Supreme Court this coming Monday, the Osborne case, and many of you know about it. Let me give you a little bit of background, just factual background about the case, and then explain as best I can the legal issues that are involved and why they are so important to the innocence movement and to the fairness in criminal justice in America today. So briefly, William Osborne was arrested and convicted as a result of a rape in Alaska that occurred in March of 1993. As with most of the exoneration cases that we've seen and most of the DNA cases that we've seen, this was a brutal crime, a very serious crime. A woman was attacked and raped by two men. The police eventually found one of the men named Dexter Jackson. Dexter Jackson at some point implicated William Osborne. Mr. Osborne went to trial on that case, and the only evidence against him was the eyewitness identification of the victim. And as in most of these cases, the eyewitness identification was not that solid. She had given a description that really did not fit Mr. Osborne. She had made a tentative identification of him initially, but did identify him at trial. In addition, the state had, what had happened during this case was that the assailant, the rapist, had actually taken a condom from the victim, and a blue condom, which was then later found, and there was seminal fluid in the condom. Clearly, whose ever seminal fluid that was the rapist in this case. In 1993, however, as you know, the DNA testing was not very sophisticated, and the best the state could do at that point was to say, based on its biological testing of this evidence, that he fit within a kind of 14 to 16% part of the population who would have secreted as he did in that case. Again, not sophisticated DNA testing. He asked for further testing, but it was not done in his case. He was convicted. Post-conviction, he continued to insist on his innocence and continued to request DNA testing. In 2001, he filed an action in state court in Alaska, seeking at that time the more advanced DNA testing, which we use today, and was denied. The Alaska courts basically said that since the evidence was overwhelming in this case, and that since the testing would not conclusively prove that he was innocent, although it probably would, they denied that testing. Having failed in the state courts, Mr. Osborne, with the assistance of lawyers in Alaska and the Innocence Project in New York, filed a suit in federal court, and this is the interesting part of this case, filed a suit under the Civil Rights Act. And this was based on a strategy that we had developed about 8 or 9 years ago, where prosecutors or police would not turn over DNA, to go to federal court to ask a federal judge to rule that post-conviction, even though someone had been convicted and their liberty interests were obviously diminished, if there was DNA testing that would conclusively show innocence, if it was tested and showed that this was not the person, that there was a due process right to access to that evidence. That was a theory that was developed. We had a case in Philadelphia 8 years ago where a federal judge recognized that, the Gottschall case, a case actually similar to Osborne, a case when you read the transcript, as I'm sure many people in the Osborne would say, probably guilty. The Gottschall case, there was a confession, there were 2 eyewitnesses, there was a jailhouse informant, all of whom testified against Mr. Gottschall, and in fact his confession had details only the rapist would know. District attorney refused to turn over the evidence. Why? Because he's guilty. A federal judge ordered the evidence to be turned over, and ultimately Mr. Gottschall was exonerated. Fortunately, and this is an important part of the context of this case, in most situations where there is DNA evidence and a possible exoneration of someone who's been convicted, district attorneys and police around the country voluntarily turn over this evidence. There have been 232 exonerations by DNA, and in over 80% of those cases, the evidence was turned over voluntarily by the prosecutor or by the police. And that should be done. There's really no argument not to turn it over. In most cases, the defense was willing to pay for it. There's no burden on the state to have that evidence tested. And given the balance of what's involved, possible exoneration and innocence, our view has been over the years that there's really no argument on the other side not to turn it over. Indeed, once the exoneration started, as you know, in the past 15 years, most states, indeed 44 out of the 50 states today, most states have passed statutes permitting post-conviction DNA testing. Some are more liberal than others, but 44 of the 50 states permit post-conviction DNA testing where there is DNA evidence, it wasn't tested at trial, and could demonstrate innocence at this time. Alaska, unfortunately, is an outlier. Alaska does not have a statute. It's one of the 6 states that does not. And when the Innocence Project approached the prosecutors in Alaska, as I mentioned, they were unwilling to turn over the DNA evidence, hence the civil rights action that was brought in federal court, which was successful initially in the district court and then in the Ninth Circuit Court of Appeals. Both courts said that when you have evidence like DNA, which is really the gold standard in criminal investigations, that's used to incarcerate hundreds, perhaps thousands of people every year, has been used to exonerate 232 people everybody else in this country thought was stone guilty, that when that evidence is available, even after trial, even after someone has been convicted, the state has an obligation to turn that evidence over to the defendant so it can be tested. Obviously, if it shows innocence, hopefully the person will be released, or there could be post-conviction proceedings. If it confirms guilt, so be it. Going forward, obviously, testing is done in virtually every case in which DNA is found these days, in which there's biological evidence, and we live with the results, both for the prosecution and for the defense. Once DNA establishes yes or no, there's usually not much else to argue about because the testing is so advanced and so scientific today. So the issue that the Ninth Circuit decided, the Court of Appeals decided, was that just as a prosecutor at trial has to turn over potential exculpatory evidence, they should also have to do it post-trial, at least when that exculpatory evidence is as powerful and dispositive as DNA is, given our scientific advances in DNA testing. That was the ruling. The Supreme Court granted review of that case based on Alaska's petition, and the case will be heard this coming Monday. And the critical legal question is whether due process, the protections of due process in the Constitution extend beyond the trial phase, extend to this post-conviction stage, and whether because of the unique power of DNA testing, the court should, in a sense, extend due process rights post-conviction to require prosecutors to turn over evidence post-conviction that they would have had to turn over pre-trial or during the trial itself. That's the issue the Supreme Court has to decide. The state of Alaska argues that the evidence was overwhelming. This will lead to a flood of such petitions, and there ought to be finality in criminal prosecutions. At some point, the defendant doesn't get back to court regardless of what the defendant says. I dare say I think those arguments are quite weak. I also say I'm not sure how the Supreme Court will rule. We'll find out. As to overwhelming evidence, when you look at the 232 exonerations around the country, virtually every one of those cases looked overwhelming when you looked at the facts in those cases until DNA exonerated the defendant. As to the floodgates, there have been very few of these cases because most states, thankfully, have passed statutes allowing this kind of evidence to come in. And as to finality, which is certainly an interest that we have in the criminal justice system, it seems to me that finality has to give way when we have evidence that may conclusively prove innocence. So that's the issue. I should mention one other thing in terms of the Supreme Court briefing and argument. On our side, not only do we have the legal arguments that are made by Innocence Project lawyers, but there are a number of very interesting and persuasive amicus briefs filed by organizations and individuals who have an interest in the issue in this case, including exonerees, including former prosecutors and police officers who recognize the essentials of testing DNA, even post-conviction, and a brief of victims of crime who know the power of DNA not only to clear people who may have been convicted improperly, but also to find the real criminals. Because in many of these cases, not only have we achieved exoneration when we've done post-conviction DNA testing, we've also been able to put that DNA into the databanks, the national databanks, CODIS, and get cold hits. And in about 15 or 20% of the cases, I believe, at this point, that has led to the actual perpetrator of the crime. It's a win-win situation. Why the state of Alaska and the United States government and 30 other states are on the other side is a question. But as I say, we'll see how the Supreme Court decides it. We'll have a decision by the end of June. But more important from what I said, you're about to hear from a number of persons who have firsthand experience with the criminal justice system and DNA. So I'd like to hear from them at this point.
Thank you, Professor. And as he said, we're about to start hearing from a number of people today who have a really compelling personal connection to this issue. And first of all, I want to thank all of them for being here, because this isn't an easy thing to talk about. It's not easy to stand in front of an auditorium and talk about one of the most painful things that could happen to anyone. So I really appreciate that all of them have come here today to share their stories. The first person I want to introduce is Marvin Anderson. Marvin Anderson has a special place in our heart at the Mid-Atlantic Innocence Project because we did work on his case in conjunction with the Innocence Project in New York. And he has been a wonderful spokesperson for reform in this area and has been really willing to share his story to students and to people all over this area and all over the country. So I want to thank him for coming today. Mr. Anderson was convicted of rape, abduction, and robbery in 1982 in Hanover County, Virginia. He was convicted based largely upon erroneous eyewitness testimony, which was helped along by a not-so-great photo array put together by the police there. He served 15 years in prison and was released on parole in 1998. But Marvin was determined to prove his innocence even after that. And he was finally exonerated through DNA testing in 2002 when Governor Warner ultimately pardoned him. So I want to welcome Marvin and invite you to come up here and share your story. Thank you.
Thank you, Sean. 1982, 18-year-old young man. You know, at that age, you look at life as a new beginning. That's how I was facing my 18th birthday. The summer in 1982, doing my normal thing a child would do, have fun, enjoy life. Working, running fire department, but my life stopped then. I was accused of raping a Caucasian female. Went to trial in December, was found guilty and convicted, sentenced to prison for 210 years. 18 years old, young man, life stopped. That's what I felt like. Went to prison, spent 15 years there. The whole ordeal, I continued to fight along with my family, and there has been times that you want to give up, but there's something in you that won't let you give up because you know you are innocent. That's how I felt those 15 years. 1997, I was paroled, came home, and I still fought. I knew in my heart, my family knew that I was innocent, and I was determined to prove that I was innocent and retrieve my name back. A lot of people don't realize it, but when you are convicted of a serious crime, your name, your family name, your whole life stops. There's nothing you can do. You can't get a job. Some people can't walk down the street and keep their head up high. What happened to me and my brothers and sisters, it happens every day. This case about William Osborne touched me so deeply because even after I was exonerated, this problem was other states that refused to allow DNA testing. Now think back, I was paroled in 97. In 2001, 2002, I was exonerated from the governor. Same situation here. The evidence that was in my case, the whole 15 years I was incarcerated, the courts kept telling me there was no evidence, none whatsoever. So for 20 years, there was no evidence in my case. But the Innocence Project, my family, they continued to fight. And we finally received a phone call saying we found some evidence. We would like to have it tested. Good news. For me it was. But the state stopped it. Similar to the case that's about to go before the Supreme Court. There's evidence to prove someone innocent, but the state refused to have the testing done. Once the testing was done, it excluded me as being the rapist, perpetrator of the crime that was taking place in '82. But it also proved who the real attacker was. Today, he is now in prison for the crime that I have spent 20 years fighting to prove my innocence for. So Mr. Osborne case does have a deep part in my heart because what he's going through today, I've already gone through that. But with the help of the public, the information that's out there to the public, we all can stop and help change the system from the way it was to have the system move forward and build to a new life. So with my prayers and blessing, I do hope and pray that the Supreme Court will grant this motion and have testing done. Thank you.
Thank you, Marvin. Anyone who was here on Monday to hear John Grisham speak heard a little bit about the Dennis Fritz case. And we're really honored today that he's here in person to share his story. Mr. Fritz was convicted of a murder in Oklahoma in 1988, based largely on testimony from a jailhouse informant and based on scientific testimony that wasn't particularly solid. He was sentenced to life in prison, and his co-defendant, Ron Williamson, was sentenced to death. And in 1999, they were both finally exonerated based on DNA testing. And later on, their case became the subject of the book by John Grisham, The Innocent Man. So I'd like to invite Mr. Fritz on the stage today to tell his story. Thank you.
Thank you, Sean. It's just an honor for me to be here in behalf of the William Osborne case, which, as Marvin stated, goes deep, deep to the core of in my heart, that this man is having to go through the same things that I went through, the terror, the horror, the pain of having your family to go through this type of exposure too. I was arrested. It was a nightmare out of hell. And my daughter was at a young age at that time, about 6 years old, when her daddy was being charged with first-degree capital murder. They filed the death penalty on me. There was just only one problem. I didn't know anything whatsoever about the murder. I didn't even know the victim, Debbie Carter. So here I am. I was appointed a bankruptcy attorney to handle my case. I was very, very naive at that time. Of course, you know, most of us are. You know, when you're facing the death penalty of first-degree capital murder that you don't know nothing about, you know, it is so overwhelming, the feeling that sweeps over you and engulfs you. It paralyzes you. I recall specifically that throughout the whole process of up into the trial, it's like my mind locked up. You know, you've got all these people accusing you and accusing you of doing something so incredibly horrible. Mr. Osborne has suffered all of these years in prison for something which we all believe that he's totally innocent of. And in my specific case, such a weak evidence. They manufactured what evidence that they did bring about, which was snitch testimony. And jailers, other inmates seeking leniency, you know, and it was just, all I can say, it was excruciatingly overwhelming. And, you know, but as Marvin stated, you know, when you're behind the 8 ball and the chips are down, just as Mr. Osborne now is fighting with everything, reaching out, and everyone that is behind him, this is a force and it's rolling. And we do hope and pray that, of course, the United States Supreme Court makes the right decision. In my specific case, the man who committed the murder was the individual who testified against my co-defendant, Mr. Williamson, who has passed on now. It's also the subject of John's book, him and I. But Mr. Gore stated that he had lied that he had seen Mr. Williamson at the nightclub on the eve night of her death disturbing her. The very man who was found out later, 12 years, that he was actually the perpetrator. All during this time, after from the county, well, after I got in prison, I started working on my own case. I mean, I walked, I talked, I breathed, I slept. Everything was focused on myself getting out of the penitentiary and proving my innocence. And you just cannot believe the excruciating torment. The prisons they're not easy. It's a loony bin. And trying to focus and do law and learn and that type of environment was very, very, very difficult. I was denied DNA testing all the way from post-conviction forward by the state court. The federal courts completely ignored my request. As a matter of fact, the state court in Oklahoma on post-conviction didn't even, I filed the motion, they didn't even come back and recognize that I had even filed a motion for DNA testing. You know, I cannot think of any worse thing than to be charged and convicted of a horrible crime of murder, of something that you didn't do. But what is even worse than that is to be denied your opportunity. We each have a right, and one right to prove our innocence. That's what Mr. Osborne only wants. And for various reasons, which in my mind there are no reasons why someone would want, to stop this man's opportunity for him to prove his innocence. And I feel a powerful energy in this room right now, and I feel that the Supreme Court will do the right thing. I pray that they will, and I just want to thank each and every one for being here with your powerful support. Thank you.
Thank you, Dennis. We're glad to have you back in D.C., and we're glad you flew all the way across the country to come here. We're also really happy that Rickie Johnson has come here all the way from Louisiana to share his story. Mr. Johnson was convicted of rape in the small town of Manny, Louisiana in 1983, based largely on the victim's misidentification of him after a flawed lineup. He served 25 years, which I think is probably more than some people in this room have been alive, in Louisiana's notorious Angola prison. And DNA testing proved his innocence just 1 year ago. So Mr. Johnson's been out for 1 year, and we're happy that he's come here so soon to share that with us. Thank you.
Good afternoon. My name is Rickie Johnson. Like she said, I got convicted of aggravated rape in 1983. I was arrested in 82. I served 25 years in Angola, Louisiana, the most bloodiest prison in the nation at that time. Thank God I made it out alive. Thank God for DNA. I could feel where Mr. Osborne is at. I done been there. All I have to say is I hope we be strong, and God bless the people that sit in the Supreme Court to rule in his favor. The evidence in my case was overwhelmed, they say. I was just the average guy working a 9 from 5. I live in a small town, Leesville, Louisiana. I still yet today don't know how they come up with me in Manny, Louisiana, which is another town. The perpetrator, they say he's fit my description, my same height, same age bracket. His name was Marcus Johnson, which my name is Rickie Johnson. I don't know how they come up with a Marcus Johnson from Rickie Johnson. But the girl identified me out of a picture lineup, which I was the only guy that wasn't from that little part of the country in the picture lineup. So there was a railroad right there. And they gave me a court-appointed lawyer, which I didn't have any money to afford a lawyer. I saw him about 2 times before the trial. I went to trial in front of a judge and a jury. The district attorney, he just took over the floor. He ruled that part of the country. I could tell from the first day. I had a 3-day trial. The first day I could tell that the district attorney ran the courtroom. They came to me and offered me a 10-year deal. I couldn't take the 10 years because I couldn't say that I did something that I didn't do. He ran a blood test. Back then, the technician testified that it could have been any 40% of a black male with a type O blood. DNA didn't exist back then. Okay, that's all the jury heard. I had type O blood. They didn't hear the 40%. I had type O. I had to be guilty. I fit the description. Okay. They sentenced me to life without benefit of parole or probation or suspended sentence in notorious Angola, Louisiana back then. I went to prison, got in law library. I filed all kind of briefs and writs and everything I knew, which I was ignorant to the law at the time. I met some people that knew a little something about law. And they helped me with everything I filed, they denied. Everything I filed, they denied. I almost gave up. I'm not going to say I didn't. I almost gave up, but the inner strength in me kept me strong through the years. And in 2002, I wrote a letter to the Innocence Project in New York. They took my case. About 2 years later, I got relaxed then because I knew I wasn't the guy that committed the crime. And I knew if the only thing that I was really worried about, it was so many years had passed by, did they still have the evidence intact? And when I found out they had evidence intact, and it was like the big wedge off of me. You know, I felt a whole lot better because I know I was coming out of prison. I never gave up. I never gave up. And for Mr. Osborne, I hope the best for him. I know what he feels. I know where he at. The district attorney in my case that approved, that turned over the evidence to get tested, he's not the same district attorney that was in the town when I got convicted. Some kind of way they got rid of him. And the district attorney turned over the evidence to the Innocence Project. They tested my DNA, and they come up with a no-hitter. It wasn't me. That was good. But they told me they couldn't let me go right there. They were going to have to run it through the data bank to see can they find a match. That's the way it works in Louisiana. They ran it through the data bank, and 2 days later, they called me. The guy that had committed the crime was there in the prison with me, and he had been there for 24 years. I found out that he had admitted the same offense in the same area that following year, but he got caught on that one, and he was serving a life sentence in Angola for that crime. And when they cut me loose, 2008, January 2008, the 14th, they rebooked him. Since I've been out, 2009, make 1 year, I started my own business, a leather business. I make leather goods, purses, hats, belts, shoes, you name it, I could do it. That's a trade I learned when I was in Angola. I wasn't off into the stupid stuff that go on in the prison. I did everything, tried to do everything positive. I'm not saying I did everything positive because I had to act a little stupid when I went there because of the stupid prison. So, but on through the years, I did do some positive stuff. I learned the trade when I got out. I put it to use. Now I'm a proud owner of R&J Leather Company in Leesville, Louisiana. And thank God for DNA.
Thank you, Rickie. We really appreciate you coming here today. Now we're going to switch gears a little bit to another aspect of this issue. We're really grateful today that Michele Mallin has been able to join us. In 1985, Michele was a sophomore at Texas Tech University when she was raped. There had been a serial rapist on campus who had attacked 5 other women. And Michele identified Timothy Cole as the rapist, which led to his conviction. In 1999, Mr. Cole died in prison of complications that were related to asthma. Several years later, there were some students working on the case, and they approached Ms. Mallin with evidence that Mr. Cole was actually innocent of the crime. And a lot of people at that point would have said, he's dead, I don't want to talk to you about this anymore. This case is over. But that's not what she did. Ultimately, Ms. Mallin joined the Cole family in a really incredible effort to posthumously exonerate him. And earlier this month, some of you may have seen this on CNN in the past couple of weeks, I don't know, but earlier this month, Ms. Mallin joined them and testified at a hearing in Texas about the case. And the judge actually recommended vacating Mr. Cole's conviction, although the case is still pending. But in the meantime, this case and a lot of cases like this one have given new momentum to the issue of eyewitness identification in Texas. Because, as you can see based on all of the men who stood before you today earlier, Ms. Mallin isn't the only eyewitness out there who happened to be mistaken, because mistakes happen. And so that's given a lot of credence to these issues in Texas. And we're really happy that she's able to join us today. And I want you to join me in welcoming her. Thank you very much.
In 1985, I was a sophomore at Texas Tech University, and I was moving my car to a parking lot across the street from my dormitory. And I knew I was only going to be gone like 5 minutes, so I didn't think it would take that long, so I didn't ask anybody to go with me. And an African-American male approached the side of my car, the passenger side, and he looked like a student. He looked a few years older than me, but not much. So I just thought he was a student. He said he needed some jumper cables, and I said I didn't know if I had any, and I said if I did, it's my parents' car, and I had no idea if I even had any. And all of a sudden, within a few minutes or less, he just opened my car door, put me in a headlock, and put a knife around my throat. And I'm kicking, screaming. I think I wet my pants. I mean, everything, that could happen. I was just trying to do anything I could. I realized, quickly that I had to get out of this situation. And but he kept telling me to stop screaming. I'm going to kill you. I'm going to kill you. I'm going to kill you. And so finally, I realized I better calm down if I'm going to, I've got to use my wits to get out of this. So alive. And he drove me out into the middle of a field, and I thought it was just somewhere outside of the loop in Lubbock, and I had no idea where I was because I was looking around, seeing if there was some place, because I was always real tiny and I was pretty athletic, so I figured, well, I could just run. I mean, he only has a knife; he'd have to throw it to me or catch me first. But there was nothing around for me to go to, so there was nothing to run to. So, and he kept threatening that he had a gun. I never saw a gun, but he kept threatening. I did see the knife because he had it to my throat the whole time. But, and I begged, pleaded, screamed, cried, told him, I was a virgin at the time. I was a 20-year-old virgin, and he didn't believe me that I was a virgin, and he kept telling me, oh, you're not a virgin, and I did everything I could to try to persuade him not to do this to me. And, but he wouldn't listen, and he raped me. And the crime happened at 10 o'clock in the morning, and I got home in my dorm. He finally let me off. He let me go, thank God. And I got back to my dorm at 1 a.m. in the morning, and I reported to the police immediately. I told them that he was a non-smoker. He was a smoker, and he smoked 2 or 3 cigarettes in my car the whole, in only a 3-hour period, and he touched the cigarette lighter. And I told him that. I said, I don't smoke, so there's, that should be his fingerprints on there. And apparently, I just learned too that that they did get Jeff Blackburn for the Texas Innocence Project. The lead counsel there told me that they did get prints from that, but the Lubbock PD threw it away. So then anyway, I guess it was only a few weeks later, first week of April, they had the detectives called and told me that they had a suspect, and they wanted me to come down to the lobby at the dorm and find and look at some pictures. And I told them that I thought that was him. As I've recently learned, though, that I didn't know this at the time, but apparently Timothy's was the only color picture in the lineup, and it was a Polaroid, and the other 5 pictures were all mugshots, and they were all facing to the right. Timothy's, their heads were facing to the right, and Timothy's was facing forward. So, but I didn't know that at the time. So I guess, like Jeff Blackman was telling me, it was a flawed lineup. Anyway, and I went to trial. Then we did the physical lineup the next day, and I picked him out again immediately. And I really honestly believe that it was him. I just was very positive at the time that it was him. And I also assumed, at the time, I just assumed that they had other evidence. Of course, I knew they didn't have DNA evidence because that wasn't a possibility back in 1985, but I assumed that they had listened to me. He had left a cigarette butt on like a half-smoked cigarette on my car seat, and I remember thinking to myself as I'm driving away, don't touch that, that could be evidence. He should have his fingerprints on there. And I thought, I just thought they had other evidence other than just my testimony. I had no idea it was just my testimony that they had. And we went to court about a year and a half later, and I testified against him, and I really honestly believe that we had found the right person. I didn't have any idea that he was the wrong man. But after trial, I went through counseling, lots of it, but I moved on and I got married, and I've been married almost 19 years now. And then this past year in May 21st, 2008, you were saying that I got a call from the Innocence Project. That's not really what happened. I got a call from the Lubbock DA's office. A man named George White called me and told me that Timothy had died in prison. And my first reaction was, that I said, well, why are you? And he told me he died in '99, and I'm like, well, why are you calling me 9 years later to tell me this? And he's like, well, there's more to it. And I said, well, what is there to it? What more is there to it? And he said that Timothy has been concluded as being not the man who raped you. His DNA has been tested, and he's not the man. Apparently a man named Jerry Wayne Johnson, who had been serving apparently now almost 24 years, close to 23 years in prison already for 2 other rapes that happened right after mine. He started confessing in 1995 after the 10-year statute of limitations had already run out. And but the Lubbock prosecutor, who was a judge now, Jim Bob Darnell, threw the letter away, and I knew nothing about that. They didn't call and tell me or anything. I didn't know anything about this until 2008 in May. And so I was just I was shocked at first. That was my first reaction in May when I found out, but I believed it. I believe DNA evidence is conclusive, and I believe that if it says that, the guy didn't do it, that, Timothy didn't do it, But I honestly I felt guilty. I felt horrible. I felt this was all my fault. And I've learned that the police did a lot of things that they shouldn't have done. And I've learned that it's not my fault. But, you still feel bad that it happened. And especially, he's a human being and he deserves to be here. And, but I've gone back in counseling, and I'm working through it, but I still wouldn't change a thing about knowing the truth. The truth is that Timothy didn't do it, and Jerry Wayne Johnson did, and it deserves to go down. Jerry Wayne Johnson cannot be prosecuted for it, but at least they can know that the truth and have Timothy's name exonerated. And I joined Tim's family to exonerate his name because it was the right thing to do. It was just, that's all I was trying to do 24 years ago when I was raped, was to do the right thing and put a guilty man in prison. And I honestly thought I was doing the right thing. I had no idea that the police didn't have all the evidence, and they didn't have anything that they should have all of it that they should have had. And I'm doing it now because it's the right thing to do for people like these men who they didn't deserve what they got. And Timothy didn't deserve what he got either. And his family, I've met them, and they're just the nicest people in the world. Y'all would love them. He's 5 brothers that are awesome. I mean, I told my husband, I said, I feel like I have 5 new African-American brothers. They're just so cool. They're just really, really nice, and they just really welcomed me. And but they're really, really good people. I can't even imagine any of them doing that. And their mom is just like, just like my mom. She's just a, great mom, loves her kids, and, no-nonsense mom. And yes, we did go to court. The court of inquiry was February 5th and 6th in Austin. And the judge did recommend exonerating him. I think they said that he had to write an opinion. I don't know all that legal stuff, but that's what they said was going to happen. It is pending, like you said, but it looks like it will go through, I guess. And I'm here because I believe that everyone has a right to this testing, and that's why I signed the Osborne brief myself, because it's just the right thing to do, that everybody deserves that right to have that DNA test if it's, to prove that you're guilty and innocent. And you shouldn't have to spend, God forbid, 27 years in prison to have that done. I mean, that's ridiculous, And I've heard, too, that some crime victims oppose DNA testing because it can reopen wounds. And, I mean, yeah, it's reopen wounds. I'm not going to lie to you. I mean, I never really thought much about the rape after about 5 or 10 years. I mean, I was married. I was happy, and, it had passed and everything. And, yeah, it's reopen wounds. But you know what? I still would, the truth shall set you free. I mean, you may have heard that phrase. And I still wouldn't have it any other way, because Timothy's family, even though he's not here anymore, his family are, and they need to know the truth, that their son and their brother and their uncle, and he was not a rapist, and he didn't do that. And the person who should be held responsible is Jerry Wayne Johnson, and he's at least go down on the records that he is the one who did this to me. And it just doesn't make any sense to me why that we shouldn't have DNA testing for anyone who needs it or wants it, or it should be, if you think if you didn't do something, then they should do the DNA testing, just like Mr. Osborne wants. Thank you.
Thank you, Michelle. That was fantastic. Thanks for coming all the way out here today for this. The next person I want to introduce also shares Michelle's philosophy that when it comes to solving crimes, the important thing really is to find out the truth. And that's why we're all here today. I want to welcome Detective Jim Trainum, who's here today from the Metropolitan Police Department, where he's been for 25 years. And during most of that time, he's handled homicide cases, and he now runs the department's cold case unit and handles the cold homicide cases. He has personal experience with wrongful convictions, and that's really shaped his work as a police officer. And he's been someone who's been working within the system to make it more accurate. And I can say personally that I think a lot of people might assume that an Innocence Project and the Metropolitan Police Department might not have much in common. But I can tell you personally that Jim has been a great advocate for these issues within the police department and has really spent a lot of hours and probably countless days working to ensure that the system works right. And that's why he's here today. Thank you.
Thank you. If I was here speaking in front of you 20 years ago as a very much younger detective, I would probably be telling you that there is no way that a person who was innocent of a crime would confess to something that they didn't do. Not unless, of course, they were crazy or had been physically tortured. That changed in 1994 when I obtained a false confession in a murder case. The suspect was of above-average intelligence with no history of mental illness. I used standard interrogation techniques. No threats, no shouting, no physical violence. However, I came very, very close to putting an innocent person in jail for life. Since then, my work has led me to review thousands of homicide cases, some across the country. And while in the big picture, I have found that false confessions aren't all that common, they happen a lot more than I had ever imagined. And I've come to understand why they occur as well. Sure, I could point to things like the improper use of interrogation tactics or misuse of tactics, tunnel vision, and things like that. But the underlying reason is the same reason that we are able to get guilty people to confess to crimes that they did commit, thus putting them at risk of imprisonment or even death. It is the same reason why we make many of the bad decisions that we make in our life, and even one of the reasons that our president gave last Tuesday for the current state of our economy. A situation is created where it seems that the short-term benefits outweigh the long-term consequences. An interrogator, like any good salesman, is very, very skilled at creating such a situation. Given the right set, or I should say the wrong set of circumstances, it could happen to anybody here. Knowing this, we in no way should use a prior admission of guilt as a reason to deny someone the ability to use a simple test that could prove or disprove their innocence. In the case of Mr. Osborne, I don't know whether or not he's guilty or innocent. But I do believe, whether it is videotaping of interrogations, post-DNA conviction testing, or other similar issues, that law enforcement, and by law enforcement I mean cops and prosecutors, it's our responsibility to take the high road. Though the courts demand only that beyond a reasonable doubt, we in law enforcement should always strive to surpass that goal in all stages of the investigation. There is a very popular quote that is used by law enforcement. I see it on letterhead, emails, posters, all kinds of stuff. The quote is, "To the living we owe respect, to the dead we owe the truth." If that is truly our motto, if that is truly what we believe in as law enforcement, then we should not be standing in the way of post-DNA testing, post-conviction DNA testing. Thank you.
Thank you, Jim. Now I'd like to invite all of the people in the room, because there are more than you heard from, who have been exonerated through DNA, to join me on the stage. Do you want to go first? I want to go first. Okay.
Well, as you all know, my name is Dennis Fritz. I currently live in Kansas City, Missouri, and I was convicted in the state of Oklahoma, which, by the way, does not have a post-conviction DNA testing statute. And that's really funny, since the fact there has been 10 exonerations from Oklahoma since I was released. But anyway, I currently live in Kansas City, Missouri, and I try to bring about a greater awareness of false convictions. And I travel all over the country and work with Innocence Projects and law schools. And it's just been a great pleasure to be here today. Thank you.
Good evening. My name is Julius Earl Ruffin. I was convicted of rape, statutory burglary, 3 counts of sodomy back in 1982. I was sentenced to 5 life terms in prison. My accuser said that she was 100% sure, and DNA testing freed me. Well, actually, I went about doing it myself, along with a couple of guys inside the system, and DNA freed me in 1982. I'm currently living in Portsmouth, Virginia. I had a book written by Magnolia Holiday, and the title of it is "Why Me When It Could Have Been You?" And it's a very interesting book. It tells you a little about my childhood and what I went through while I was inside of prison and how I fought the system. Thank you very much.
Good evening. My name is Rickie Johnson. I'm from Leesville, Louisiana. I was convicted of aggravated rape in 1983. The girl that accused me, she was 100% sure that I was the guy. I was exonerated in 2008. I did 25 years in Angola, Louisiana, the most bloodiest prison in the nation. I've been out 1 year, January 14, 2009. I started my own business, R&J Leather Company. I'm doing pretty good. I still live in Leesville, Louisiana. And I just hope what I went through, no one else has to do it, which I know it's going to be done, but thank God for DNA.
My name's Jeff Deskovic. I was convicted in 1990 in New York of a murder and a rape. I served 16 years in prison for that crime. I was convicted based upon a false confession which was extracted from me at the age of 16. The fabrication of other evidence, prosecutorial misconduct, my public defender also what was inept. I was exonerated in 2006 through DNA, which I went beyond proving my own innocence. We actually proved the guilt of the real perpetrator through that testing. Today I lecture on the topic across the country and I write articles, and I'm in the master's program now in criminal justice, and I hope one day to be an attorney. Thank you.
My name is Marvin Anderson. I was tried in 1982 for 2 counts of rape, sodomy, robbery, and abductions. I was sentenced to a total of 210 years in prison. I spent 15 years in prison, 5 years out on parole. Since I have been exonerated in 2001, I have been continuing with this fight to have the public be aware of what is happening and what has been happening for years. We as citizens now, because we are citizens, at one point in time we wasn't, but we as citizens have that right to fight to change the state of mind of the justice system that it is today. So as long as I am still breathing fresh air and I have my mother behind me to fight with me, we will continue this fight that justice be prevailed as far as people being aware of what can happen to them any given day. Thank you.
Thanks so much to all of you. Together, the men standing in front of you spent more than 120 years in prison before DNA testing was able to prove their innocence. And a lot of those years were spent fighting to find DNA to test and fighting for access to actually test it before they could finally prove what they had known all along, which is that they were innocent. And nationwide, there are 232 people just like them who have been exonerated based on DNA testing, who have collectively served hundreds of years in prison for crimes they simply didn't commit. And I'd like to invite Michele Mallin and Detective Trainum to join me on stage right now. Come on up here. Michele and Jim represent a growing number of crime victims and law enforcement officials who have become really concerned about the problem of wrongful convictions, because not only is the wrong person convicted, but the right person remains free. So they want to make our criminal justice system as fair and as accurate as possible. And that's what the Osborne case is all about. You know, we don't know right now whether Mr. Osborne is guilty or whether he's innocent. But what we do know is that we have a tool out there. We have DNA evidence that could tell us one way or another whether he did it or whether he didn't do it. And it's important to all of us to recognize that the system should never give up on the quest for the truth just because the jury has rendered a verdict. And so I hope you are all looking forward to the Osborne arguments on Monday. The decision should be reached sometime in June, we think, and we're keeping our fingers crossed about it. And I just want to thank everyone who's come out here today, because as I said at the beginning, these aren't easy things to talk about in an auditorium. So I really appreciate that everyone has come out here today to share these stories, and I hope I'll see some of you at the court on Monday. Thank you.